Welcome to today's program titled Securities Litigation and Regulation in the COVID Era, Recent Developments and Expected Trends. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you're encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn it over to Greg Markle. Greg, you may begin.
Good morning or afternoon, depending on where you are. This is Greg Markell. I am a securities litigation partner at Seyfarth Shaw, as is each of the speakers. We are part of a larger team of partners and many associates who do securities litigation primarily at Seyfarth Shaw. I am going to turn this over now to Daphne Mordutevitz. Daphne is a securities litigation partner and who joined us with a group of partners in January and has been a great addition to the Securities Litigation Department, and she will begin the program that we have today. Thanks very much. Go ahead, Daphne.
Thank you, Greg. The last few months have been a time of unprecedented social and economic upheaval, with markets plunging and previously healthy companies facing risk of collapse. These are often optimal conditions for securities class actions. As we discussed in our last webinar, plaintiffs began filing securities actions in March against companies that are on the front lines of the COVID-19 outbreak. We discussed the Norwegian cruise line, Inovio Pharmaceutical, and Zoom video cases on our last webinar. Since that time, a shareholder derivative suit was filed on April 20th in the Eastern District of Pennsylvania related to the Inovio case, alleging that defendants breached their fiduciary duties by allowing the misrepresentations alleged in the securities suits filed against Inovio. This is not unusual and will likely see additional tag-along derivative suits as more securities cases are filed. There were also 6 additional COVID-related private securities suits filed. These include a suit filed against Sorrento Therapeutics in the Southern District of California, with claims similar to those asserted against Inovio. The complaint alleges that the biopharmaceutical company overstated the prospects of its antibody against COVID-19, causing an inflation of its stock price. And on May 27, Carnival became the second cruise line company to face a private securities class action. The suit alleges that the company concealed information regarding the number of COVID-19 transmissions on its ships, its failure to comply with its own COVID-19 safety protocols on ships, and its failure to disclose infections on board in violation of port of call regulations. A second complaint was filed against Carnival yesterday with similar allegations. There have also been a number of other COVID-19 related securities fraud cases filed against companies, both by shareholders and by the SEC. These cases involve alleged failure to disclose the impact of the pandemic on defendants' businesses and focus on companies like the cruise lines that have been adversely impacted by the pandemic. Other targets are companies like the pharmaceutical companies that are alleged to have misrepresented their ability to sell and profit from products in high demand as a result of the crisis. Some examples of the defendants in these cases include companies purporting to sell or develop face masks, test kits, hand sanitizer, and temperature reading technology. These cases appear to be of particular focus to the SEC, as we will discuss further later. Another case filed against a company adversely impacted by the pandemic is the case filed in the Southern District of New York on April 24 against Phoenix Tree, a Cayman company with ADS listed on the New York Stock Exchange. The company rents apartments in China, including in the Wuhan area, for co-living arrangements. And the complaint asserts Section 11 violations related to offering materials in connection with a January IPO. It alleges, among other things, that the offering materials generally listed pandemics, among the potential risks to the business, despite the fact that at the time, according to plaintiffs, the company was already facing adverse impacts from COVID-19 as tenants became sick, lost employment, or otherwise had difficulty paying rent or honoring their leases. 4 cases have been filed in the last 2 months in the Southern District of New York against Untitled Chapter, a Canadian company in the cannabis industry with shares trading over the counter in the United States. The complaints allege misrepresentations regarding liquidity issues that were attributed in part to the COVID-19 pandemic. Specifically, the complaint asserts false and misleading disclosures regarding escrow funds, which were supposed to be set aside to meet interest payment obligations, but were actually used for other purposes, leading to a default. One of these cases was voluntarily dismissed on April 20, but the others appear to be proceeding. Two additional cases were filed in the Southern District of New York in May against SC Works, a company that provides data management and other services to healthcare providers. The complaints allege misrepresentations regarding large purchase orders that the company purportedly received for COVID-19 rapid test kits.
Hi, Daphne. So this is Greg Markell. I do want to go back for just a moment to the Ianthus cases. The Ianthus cases have some accounting issues in them. They relate to the financial statements, the measures of liquidity, and other and escrow funds and false and misleading statements relating to those assets. And so there have also been a few other accounting cases filed first part of this year. And interestingly, last time when we had this session in March, Karen Hughes of AIG had sent a message late in the meeting to ask a question that we did not get to in that session, but it was prescient in the sense that it raised the issue of did we expect to see accounting cases down in an increasing number of accounting cases, and later, so I followed up on that question, talked to Kieran, and he had indicated that his view was there probably would be more accounting cases. Well, I think the 2 things. One, we have started to see some accounting cases. We think there are likely to be more. It's hard to predict anything in this business at the moment relating to COVID, but I do think that there's a lot of time between the filing of accounting-related cases and the time that issues are created on accounting within companies. And so it seems to me, and I think to others on the panel as well, that as companies are in distress, and we're told that we are entering probably a recession, there are certain companies that are in financial distress already. For example, has filed bankruptcy. There have been bankruptcies of several of the major retailers, and so. I think we're going to see more companies with problems. The government is doing what it can in terms of loans, but I do think there's going to be a lot of pressure on a lot of companies, large and small, to deal with the fact that these are tough economic times, and to try and keep their performance as presentable, shall we say, as possible, and those are times we haven't seen for 10 years or so. I do think that there will be accounting claims that over time emerge, and we'll be seeing more accounting problems surface as a result of the SEC or others, and I think in answer to the question that Karen had last time, I and I think others on the panel think that we will see increasing number of accounting-related cases going forward. And let me go back to Daphne. I think there are additional items that you wanted to cover, Daphne, on specific cases.
Yes, thank you. There's one last private securities case that we wanted to talk about, which is a case filed in May in the Southern District of Indiana against Elanco Animal Health Company after a revenue downturn attributed to the COVID-19 outbreak. The complaint alleges that the company failed to disclose the adverse impact of COVID-19 on product demand, company operations, and financial prospects. It's far from clear, based on the complaint that was filed, that defendants actually had scienter with respect to the adverse impact of COVID-19 on their business at the time of the disclosures. But I think this case is likely indicative of the types of lawsuits that companies may face where they fail to accurately predict an adverse impact on the business. And really, given the breadth and scope of companies affected by COVID-19, just about every public company in any sector could be at risk. So we caution companies to clearly identify forward-looking statements and include proper cautionary language in an effort to protect from these types of suits. And the other category of cases we see, and we expect to continue to see, are cases like the ones against Inovio, Sorrento, and SC Works, where a company is overly optimistic about its product capabilities or ability to profit in connection with the pandemic. Here also, we think cautionary language is critical.
Good, thank you. So there have been a couple of really, in my view, extremely interesting statistics that have come out recently, and one of them is some things that came out relating to the total number of securities cases filed in May, as contrasting with, for example, April. So in April, there were 44 securities cases filed, which is a healthy number, consistent with the recent years when we've been getting 400-odd cases a year in securities cases filed. In May, there were only 16 cases filed. And we have no clear indication of what happened. March was a number that was lower than 44, but significantly higher than May. And so, why only 16 in May? We can say, well, maybe the plaintiffs' counsel decided that they wanted to take a break and let the dust settle a little bit on how COVID cases would go. That's a possibility. It could be that it's just an anomaly in the statistics, although it's rather a big anomaly. But another factor which we think might be affecting the number of securities cases is what is happening in the IPO market and also other parts of the merger and acquisition markets. The number of mergers and acquisitions that have been announced has trended down. The number of IPOs has trended down as the COVID crisis worsened and looked like it would last for at least, as it turned out, nearly 3 months before it started to lighten up a little bit, at least in New York. And so what has happened in part is that traditional merger cases there are a lot fewer of those. I don't think that explains the whole decline in the number of cases in May, but it is a big piece of it. But there's another kind of startling statistic that we found And it actually really, in this case, well, most of what we do here is we. Daphne did some research on the Stanford law and found the section where there was a list of all of the securities cases that have been filed since the beginning of the year. And at the time, she was looking at merger cases, so she found that there were 60 merger cases filed since the beginning of the year. The astounding thing is that 52 of them were filed by Rogorski and Long and RM Law. 52. And 20-odd of those have already settled they have been dismissed, which suggests that they're filing, they filed in the first part of this year as many cases as they possibly could in merger situations, and then settled it for mootness fees. That would be a guess. I have no proof of that mootness fees because there's no way to research it. But it is an example of what is a really troubling evolution of the merger and acquisition marketplace and the litigation relating to it. We had disclosure-only settlements. Trulia largely took care of that problem, just almost entirely took care of it. Certainly took care of it in Delaware Chancery Court. And over the years since 2016, a new abuse, which in some ways is even more cynical, is the mootness fee abuse, whereby the cases are settled so early that there hasn't been a class certification, and therefore no judicial approval required. The fees they expect are probably lesser in mootness fees on average than disclosure-only settlements, but very few people get to learn of the fact that a mootness fee has been paid. And so apparently it looks like Rogorski and Long and RM Law have made a real history of doing these kinds of cases. Now, they still had to have mergers in order to commence the cases, and when merger markets slowed down, they had to slow down the claims they brought. And I think that probably ties in with the fact that May was such a light month. But we'll learn a lot more in coming months and see what the number of cases filed is, and we'll see if May is an anomaly in the cases that were filed. In any case, in my view, the statistics about the number of May cases and the statistics about the number of cases filed by two law firms in the M&A area are really very interesting, and in some ways, with respect to the latter, are very troubling. So I think that there ought to be a real push for reform such that it's more difficult to charge moot fees because it's hard to find any redeeming quality for them. They don't benefit the economy. They don't benefit shareholders of any company, and they don't do anything good for anybody except those lawyers who receive the mootness fee. Anyway, I'll now stop talking for a while, and I'd like to talk a little bit about the fact that what we have seen in the first half of this year is also a little different in that the SEC has been very active, and I'm happy to say that I'm about to turn over the discussion here to Stephen Paradise, another securities litigation partner at Seyfarth, and I think you'll find his talk on the SEC aspects, and he'll be followed by a leader of the securities litigation group at Seyfarth, Will Cricket. But for the moment, Steve, please take the floor.
Thank you, Greg. So I'm going to be covering issues that have come up with respect to SEC guidance on what should be disclosed by companies in their public filings with respect to the impact of COVID-19, as best companies are able to tell about that and predict it, as well as guidance that has been issued by the Division of Enforcement with respect to what the division is going to be doing during this period to make sure that the markets are protected and that people that are inclined to commit fraud, and believe it or not, during a time like this, many people who are predisposed towards committing fraud do seem to come out of the woodwork. And the SEC has provided guidance to let the markets know what it will be doing to make sure during this time that the markets are protected, and most importantly, of course, that the investors in the markets are protected. Will Prickett, my partner, will be discussing the specific actions that the Division of Enforcement has already brought against alleged fraudsters who are trying to take advantage of the COVID-19 situation for their own benefit. So starting with the slide, on March 25th, 2020, the Division of Corporate Finance released guidance to indicate what it believes is necessary for public companies to disclose impacts of COVID-19 to be compliant with the securities laws. In our previous webinar, my partner Vinny Sama spoke about this, so I won't spend too much time on it, but we have benefited from time that has passed since then to have a better understanding as to what exactly it is that the SEC might be doing. So one thing that the Division of Corporate Finance made clear is that it is, or it was and is, it remains impossible to predict the precise impact of COVID-19 on business operations. So the division recognizes that as a difficult thing, as with any disclosures. For those of you who are involved in making disclosures, it is very judgmental and has to be based upon the information that is known or reasonably known at the time. But the SEC has made clear that it does expect companies to disclose that any material risks to their business that are presented by COVID-19 and moving forward, and how the company or companies plan to respond to those risks. The SEC has recommended that companies proactively revise and update their disclosures as facts and circumstances change. One thing in particular, it does not come from the guidance, but I'll just point it out. If there is a risk factor in a company's most recent 10K that has now been affected or impacted by COVID-19, the securities laws require that an issuer update that risk factor in its next 10Q. That's one thing to keep in mind, and you will see, if you follow these types of things, that there were a flood of disclosures from numerous companies, those that you would expect to be directly impacted by this, such as food and hospitality companies, hotel companies, travel industry companies, and the like, but other companies as well who might not be as expected to be directly impacted by COVID-19. Those are companies whose supply chain might be impacted severely. For example, a company that sources products or materials from China would be one that you'd expect to have a severe impact. And the SEC is advising that these types of companies also go back and check their disclosures to make sure that they're timely and accurate for the investing public. On the enforcement side, which is the arena in which I generally fight, the Division of Enforcement has also provided guidance to the markets with respect to what it is doing about COVID-19. As recently as last month, just a little bit less than a month ago, the Division of Enforcement announced the formation of a coronavirus steering committee. Sorry, I forgot to change the slides. I got so caught up with what I was saying. the SEC announced the formation of a coronavirus steering committee, which it said would be focused on identifying the key areas of potential market and investor risk, and would be actively monitoring for potential misconduct, including, as I alluded to earlier, any attempts to use the COVID-19 crisis as a basis for investment scams. Again, Will's going to get into a couple examples of that in a little bit. But the four areas that were specifically enumerated by the co-heads of the Division of Enforcement are microcap fraud, insider trading and market manipulation, a specific call out to that, which I'll get into a little bit more in a second, financial statement fraud, and retail investor fraud. Now, the steering committee is comprised of 24 different leaders from the Division of Enforcement, and the Division of Enforcement made clear that they would also be working with and communicating with state regulators, exchanges, other federal agencies, and self-regulatory organizations to make sure that the markets are covered and that there's consistency and collaboration among the various regulators. With respect to microcap fraud, referring here to what I alluded to earlier, where people come out and try to claim that they have products or solutions to a major problem like a pandemic, and try to hype that to get unwitting and unsophisticated investors to buy their stock. These are generally the hallmark of a pump and dump scheme and are used in penny stock frauds. And this is nothing new. In the past, we've seen similar types of frauds emerge based on other market moving events. And the SEC has made clear that it will clamp down on this and has already brought several actions, which we'll discuss. With respect to insider trading and market manipulation, because of the volatility of the situation and the drastic moves we've seen in the market during this period, there is an opportunity for people to wittingly or unwittingly engage in insider trading. So one thing that the division has cautioned companies about is they've reminded them about their Reg D obligations. For those of you who don't know what Reg D is, Reg D requires that when a public company makes an announcement of material information, it do so at one time to all market participants. And there's a concern that in this quickly moving situation, there could be companies who trip over Reg D and inadvertently release information that relates to how their company may be adversely impacted or positively. I guess some companies could be positively impacted by COVID-19. They want to make sure that companies are not doing that selectively or doing it all at one time. With respect to financial statement disclosure fraud, this ties back to what I discussed earlier with respect to the Division of Corporate Finance. I think it's going to take some time to see this emerge, but I do know that the SEC has said it will be following disclosures by companies and seeing if information comes out later on that was known and should have been disclosed earlier. They're also going to be scrutinizing the disclosures that are being made now, especially in heavily affected industries, to make sure that companies are consistent and yet you see similar disclosures coming out of similarly impacted companies. Another cautionary word that they have provided is that they do not want to see companies using COVID-19 as an excuse to disclose or conceal other inherent or intrinsic problems that existed at the company, but they figured that because of COVID-19, they could make a disclosure now, and maybe the markets won't react as badly as they might have if the real reason for the problem have been disclosed. So that's another thing that the Division of Enforcement will be on the lookout for. And finally, retail investor fraud has to do with retail brokerage type firms, and the commission will be focused on things such as failures to honor redemption requests by customers, and also improper marketing and sale of complex structured products by brokerage firms to retail investors. Greg? At this point, I'm going to turn it over to Will Prickett.
Yeah.
Okay, thanks.
Go ahead, Will. Please go ahead. You're going to talk about SEC enforcement actions that you're seeing out there in the market. Right.
Yes, thank you, Greg, and thank you, Steve. So as Steve just mentioned, the SEC has made no secret of the fact that it's devoting a lot of resources and attention to monitoring public disclosures that are related to COVID-19, especially, particularly in the particularly in the microcap area. And where the SEC believes disclosures are potentially actionable, it's taking action. And sort of the range of actions that we're seeing are, commencing an investigation, issuing Wells letters indicating that they plan to recommend to the Commission that an enforcement action be brought, suspensions in trading, and ultimately enforcement cases. So over the last roughly 6 weeks, we have seen actually 3 pure COVID-related SEC enforcement cases brought. The first one on the slide is Praxin, and that was filed in the Southern District of Florida on April 28th. And in this case, each of these cases, the SEC is alleging violations of Section 10B and 10B-5. In Praxin, the SEC alleged that the company and its CEO issued 2 false and misleading press releases claiming that the company had acquired a large quantity of N95 masks and that it was taking orders for those masks, including stating that the mask orders were 100,000 masks minimum in order for the company to take on the order. Yet, as the SEC alleged, the company had not entered into any contracts to acquire any masks and had none in its possession and no orders from any buyer or potential buyer. Similarly, in the Applied Biosciences case, which was filed in the Southern District of New York on May 14th, there the SEC alleged that the company made false and misleading statements in a single press release regarding its ability to sell home test kits, COVID-19 test kits, when in fact the SEC's complaint alleges the test kits were really not meant for home use or for consumer use, and indeed were not even FDA approved. And then finally, in the Turbo Global Partners case, which was also filed on May 14 in Middle District of Florida, in that case, the SEC alleged that the company and its CEO, who had a prior regulatory history, made misrepresentations in 2 press releases that the company had entered into a partnership to distribute thermal scanning equipment that could scan large crowds and detect fevers in the individuals in the crowd, when in fact there in fact was no such partnership and no agreement to sell any such product, if indeed any such product actually exists. So this is an example of the enforcement actions that have been brought, and I think we will continue to see. There are a lot of companies, particularly in the micro cap. By the way, all 3 of these companies were in the micro cap space. And as I mentioned earlier, it's a major focus area of the enforcement staff. The other thing that I mentioned is that. Sorry, Greg, you have a question?
No, go ahead, please. No, please go ahead.
So, in a number of instances that we are seeing, where there is a significant movement of the stock price, typically positive or up, following a disclosure that the SEC thinks may be or is false and misleading. The Commission is shutting down trading in certain cases. In each of the 3 enforcement action cases I just mentioned, the trading had been shut down prior to the complaint being brought.
Well,
Stephen.
Yes. Didn't you have a case recently for a firm client that involved in somewhat of a similar situation with the staff of the SEC?
Yeah, actually, thank you for asking that, Stephen. We actually are representing a client. I can't say much about it other than the fact that it's the SEC's questioning of certain of the client's SEC disclosures and press releases raise similar issues to the ones in the enforcement cases I just mentioned. The good news for our client, though, is that the facts that the SEC initially understood were not accurate, and this is a company that is, in fact, making real personal protective equipment and selling it. So we're working through those issues with the enforcement staff.
Will, have you seen Stephen?
Greg, I was just going to ask Stephen a question. Turning to responding to SEC activity in this current environment where everyone is working from home. Stephen, you've had a recent experience in that regard, haven't you?
I have, and with all due respect to Gabriel Garcia Marquez, I refer to this as Wells submissions in the time of COVID. So I had a client who essentially got Wells late last year. Again, for those of you who don't know, Wells notice is a notice from the SEC that the staff has determined that your client, they believe your client has violated the federal securities laws, and they intend to recommend to the commission that they be authorized to bring an enforcement action. So our client was Wells back in, I think, late November, early December time period, and we submitted our Wells submission in early January. We then had a meeting with the staff up in the Boston office, which is the office that was conducting the investigation, on March 6th, which is just about a week or so, or maybe 2 weeks before everything came to a screeching halt. And we had our one meeting there, but unfortunately, as persuasive as I thought I was not able to convince that room to drop their case, and we needed to go up the ladder to the co-head of enforcement. And we did that by Zoom, or I don't think it was Zoom. It was some other platform that the SEC uses, similar to Zoom. And I have to say that although my preference was to meet in person, the process that we used, first of all, they would not grant an adjournment until such time as we could meet in person, because nobody knew when that would be. So we had the meeting, and it's a lot better, I think, than doing it by telephone, because you can still at least read some nonverbal cues from your audience and try to focus your argument and your advocacy on those people. At the end of the day, I can't speak much about the facts, but we were able to get the SEC to meet us somewhere in the middle, and all this was done pretty much during the COVID pandemic. So.
Will, have you seen investigations relating to the Paycheck Protection Program? Hello?
I think he may be on mute.
I'm not actually.
I apologize. Yeah, no, I'm back. Sorry, guys.
Yeah.
We are seeing some activity in this regard by the SEC, which is somewhat surprising, at least to me, because the thrust of the investigative activities being done by the DOJ with respect to whether individuals or companies have made misleading or false applications to receive funds. But the commission, the SEC, is also looking at if the company is a public company, whether its applications to the government are consistent with statements in its SEC filings or other public filings with regard to its financial condition. So it would appear that at least at this stage there are some investigations looking into whether or not there are false or inconsistent statements in the PPP application versus what is stated publicly with the SEC.
And what about whistleblower cases? Are you seeing those?
We actually have seen an uptick in anecdotally just within our firm, in our whistleblower team that's headed by our partner Chris Robertson. I think we're going to continue to see more of that in the coming weeks and months, because as more and more individuals are furloughed or laid off from employment, many individuals may look to try to replace some of that income with an ability to claim or a perceived ability to claim a wrong under the securities laws by their employer. And as we all know, under the SEC's bounty program that came out of the Dodd-Frank Act in 2011, the SEC finalized its program where it will give a reward to a whistleblower who meets the criteria, provides voluntary information, and that's original information. And in a matter that the SEC recovers $1 million or more, can receive a minimum of 10% of that and upwards of 30% of the recovery by the commission. And there's also a prohibition in the statute and the regulations against retaliating against the employee who makes that claim, even if it's a false claim. So I do think, Greg, you're right. We are likely to see even more of those cases in the current difficult economic environment.
Great. So thank you. So Will and Steve, in dealing with and avoiding SEC actors entirely, or dealing with the SEC once they come knocking on the door, have you got any practical tips for the audience?
On the disclosure front, this is not a self-serving pitch, but it's important to speak to disclosure counsel to make sure that you're covering the landscape in terms of what you know and can disclose at the time. And, just hope, of course, that something terrible doesn't come down the road, that it turns out that someone could look back and say, hey, how come you didn't disclose this earlier? So I think, generally speaking, the commission feels that more disclosure at a time of uncertainty like this is probably better than less, but too much disclosure is not a good thing either. So I think you just need to find that right balance and just make sure you've thought it through and document what steps you've taken to consider what needs to be disclosed, and then going in and either disclosing it, or if the decision is not to disclose, documenting that decision as well.
And
okay.
Steve, and I would echo that, and I think encouraging your clients to work with outside counsel to make sure those disclosures are correct. We've seen some clients that have not done that and have gotten into trouble. And if there is an issue, and if there is either a request for information informally or a subpoena or even a Wells letter, obviously I have found that very open and honest dialogue with the staff goes a long way. So cooperation typically is to the client's benefit. Okay,
so I think we should turn to our last overall general topic of the day, which has to do with insurance, D&O insurance, and other insurance issues. And so I'm going to ask Gina Ferrari, who is a securities litigation partner based in San Francisco, to lead us off there. Please, Gina, go right ahead.
Greg, before we talk about insurance considerations, I wanted everyone to think about their trading windows and their blackout periods. On March 23rd of this year, the SEC stated that insiders are likely to have material non-public information about the effect of the virus in their business, and what they've asked folks to do, and what you should be doing, is reconsidering and revisiting your trading windows and revisiting how much you need to disclose and when you need to disclose. These are also important considerations based on what the SEC has issued in its statement. And for many folks, like Stephen said, you may want to be talking to your outside counsel about ways in which you disclose, when you disclose, and what changes need to be made to your insider trading policies to make sure that you have the appropriate safeguards in place. And with that, I will say that we can talk about what kind of insurance policies and renewal considerations you should make vis-a-vis SEC enforcement actions and the PPP considerations that my partners have already talked about today. So we do know in our own personal experiences that the pandemic is unprecedented, and it's frankly and possibly maybe the largest ever catastrophic loss that we've seen in the economy. We know that folks in the industry are saying that, and we believe that that's also true, and it's going to be extending into the foreseeable future, and it's going to take a long time to play out. So what does that mean for insurance renewals? What does that mean for the industry? It means that nothing's going to be routine, right? So you can't predict risk if you can't assess the risk, and we've never seen anything like this, and it's affecting all segments of the economy, our lives, and business. If you've been listening today and to our previous presentations, we've provided you with some ways in order to avoid risk, which means you should have a lower liability, and hopefully you'll be doing all the right things so that your underwriter is really happy with how you're performing, and maybe you can drive costs down. Before I talk about the rest of these issues, I'm reminded that I did not provide you with the CLE code. So the CLE code today is SS1154, as in Sam 1154. So I apologize for the segue. Now, if you are acting appropriately in lowering your insurance risk, your liability risk, hopefully you'll be proving to your underwriters that you are doing the right things. That does not mean that renewals are going to be tough or that they're going to be cheap. There are likely to be more D&O claims with higher insolvency, and we're seeing higher insolvency in the market. Just seen some very large institutional companies go bankrupt, and that is a primary concern for folks that are underwriting these policies. And remember, prior to the pandemic, renewals were expensive and difficult because of the rise of event-driven litigation. So last time we talked, we generally advised you as companies, build in more time. It's going to take more time. So today we want to give you a little bit more information about what your insurance placement process is likely to look at. It's ever evolving right now, again, because nobody's ever seen this. And let's move to the next slide so that we can talk about what that is and how you can temper your expectations. So as a company, you want to position yourself to proactively answer the questions that are driving some of these concerns in these cases. So, for example, all the cases we've already talked about and the enforcement actions really look at issues about the impact of the virus, supply chain problems, workforce issues, labor issues, liquidity, debt, and everyone hopefully has been following all of their appropriate caremark duties and having extra meetings, but that doesn't stop now. These meetings need to continue to go forward when you're looking at reopening plans, and you need to be communicating that to your underwriters when you are looking to renew policies. So, listen, some folks are refusing to write D&O right now. So you should expect there's going to be less competition in the marketplace, less availability. Those who are, you should expect to answer a COVID questionnaire that will be time-consuming, labor-intensive. You're not going to be having turnaround time that is as fast as you may have had in the past, simply because everyone's working remotely. And there's just a lack of flexibility within the process. So frontline underwriters have less discretion. Let me just move to the slide that I want to be on. Thank you. Frontline underwriters are going to have less discretion. And what we're hearing from the industry is that there are increased layers of management approval, and there are changing in some terms, and we'll talk about a couple of the terms that we're seeing. So when you're negotiating and working on underwriting your next policy, you should expect that you should expect new terms and terms that you haven't seen, including COVID exclusions. We're seeing them in E&O policies, but you should expect to negotiate over different exclusions. You should expect to negotiate over refusals to provide extensions to the return process. And like I said, unfortunately, the cost of these policies are going up. Well, for companies, your revenue is going down. Why is that happening? Well, the risk is going up. And so you're unfortunately in one of the worst situations. You should also expect retentions and deductibles to be much higher. And finally, you should expect capacity to be decreased. There's going to be, what we're seeing is a reduced in limits, fewer competitors writing, fewer folks offering excess increases, fewer increases in Side A and DIC coverage. So what can you do? Like we said, be proactive, be ready to answer the types of questions in these COVID questionnaires and build in time. The questionnaires are going over those issues that we've talked about in each of these cases: supply chain issues, workplace labor force issues, cash, liquidity, debt, and reopening plans. You know, some companies are deciding to move away and move towards alternative structures. Tesla has decided to self-insure itself. Some folks are just buying Side A. Again, we know these are difficult decisions in a time where, for companies, there is more risk and it has higher costs. So we've been talking about today, a good portion of our discussion has been about SEC investigations. So nothing particularly new here other than with respect to the PPP loans. When you're looking at your policies, you really need to look closely at how claim and loss, insured person, wrongful act, and investigation, or prior or pending litigation is defined to see whether or not you're going to get coverage for the investigations or the enforcement acts that are related to the SEC knocking at your door. And frankly, we think that those traditional analyses of what's covered by claim or loss or prior or pending litigation will be applicable to whether or not you're going to get coverage to any investigation over fraudulent statements for obtaining PPP loans. So what we recommend is you really look closely at the terms in your policies and know that when you're negotiating new policies that there may be changes to these terms simply because of the higher risk that's going on right now. I mentioned earlier that there will be new exclusions possibly, and you should look at old exclusions that aren't typically in D&O policies. So what we're seeing is some adding back in or increasing of bankruptcy exclusions, pollution exclusions. Look closely at the conduct exclusions and look closely at the claim period. What we recommend folks to do is if you have a current policy and you think a claim related to coronavirus could be covered under that policy, make sure you make a timely claim. chances are your current policy is going to be more expansive than a new policy. And if you're looking at insolvency, you know you have additional duties. You know that you need to look closely at your insurance coverage package, and you may consider tail coverage. And as we're running out of time, I just wanted to talk about some other policies where you might find coverage for losses that seem to be arising during COVID, or you might not, which may then trigger some duties that you have of disclosure that will then trigger D&O losses. So anyone who's listening, I'm certain, is familiar with the disputes going on over business interruption coverage. And each of you that are directors and officers should be really thinking about what needs to be disclosed and how that may affect your fiduciary duties. And hopefully you are complying with all of our suggestions in the last two presentations so that you don't also have a D&O loss. We are seeing some good case law in the cyber arena. As you've heard in our last few presentations, there's certainly some cyber risks as we're all working remotely, and those can trigger D&O policies. We're seeing some good case law that are triggering fiduciary liabilities that trigger D&O policies for cyber. Again, there are different ways that folks look for cyber that aren't just the cyber-specific policies. You can look to your crime, your E&O, and your property and casualty. Maybe you'll get coverage.
So Gina, I have a question. Your presentation raised a lot of interesting issues that are actually, in some ways, difficult issues for some people in the audience who are facing the need for insurance. How important is it to have a broker that you really have faith in and trust in?
It's more essential than ever. So I know that seems obvious, but because the process is different and because you're going to be negotiating new terms, new prices, and you're going to need to look at your entire insurance package, your broker is essential.
I certainly agree with that. I think an experienced broker is really a big help in figuring out what you need and working one's way through all of these questions and good questions and issues that you've raised. Okay, so I at least I don't think I have any questions. No, I don't have any questions from the floor at the moment. If anybody has any questions and wants to type one in quickly, we'll try and answer it. But we have about 2 minutes left. So and I don't know if anybody on the panel has anything more they want to say. So anybody on the panel have something they want to raise?
Greg, it's Stephen. There's one thing I forgot to point out with respect to the disclosures. One thing that the SEC has also encouraged that and requires is that the disclosure be specific. So just saying COVID-19 may present risks to the economy and that may affect us is not a very meaningful disclosure. So if a disclosure is going to be made, it should be tailored to that company and the specific risks rather than generic risks that company faces. That's all. Thank you.
Thank you. Okay, so I don't see any new questions, although given that technology is involved, I may be making a mistake. But what I do see, I do not see any new questions, and we are within 1 minute of the full hour, so we will adjourn. But I'd like to thank the audience, and we appreciate your joining us, and we expect maybe not until June, maybe not until the fall, but we expect there'll be another update with with more developments and changes, and maybe some answers to some of the questions that have been raised, including some of the questions about why there weren't many lawsuits, many securities cases filed in June, and what the aftermath of that is. Is that going to a trend, or is that just an anomaly about what's happening with mootness fee cases and many other potential issues that may be further resolved, or new trends that we're seeing, or old trends that are continuing. So we look forward to talking to you again in a few months. And in the meantime, we stay safe, and we wish you all good health, and we wish us all that everybody that this pandemic ends, or at least continues to decline in virulence. And we also hope that the economy recovers faster than some people think it will. And with that, good afternoon.
Thank you, Greg.
This concludes today's webinar. Thank you for attending. Have a great day.